All right. Hello there, beautiful people. It's great to, well, I can't see you, but I know there's 20 of you watching in, listening in, and watching today's webinar or Zoom meeting. We call these meetings, these sessions, Money Talk, and this is our latest edition of Money Talk. We've taken the last 2 months off, and we will have this one and another one on next month, and possibly the month of December. I'm sure everyone's really excited about all the, market fluctuation and all that stuff that's going on right now. I'll talk to that a little bit after this meeting. We anticipated that the markets would be volatile leading into the elections. And in fact, the markets have not been as volatile as we thought they would be, but they're, it's getting to be, this week was probably the most volatile we've had, okay? But we have a great speaker lined up for you today. And our speaker today is with Pacific Life. Her name is Michelle O'Haron. And Michelle is a senior retirement strategies group consultant with Pacific Life Insurance Company. She brings over 25 years of industry experience to her role, including experience in financial planning and wealth management. She began her career in the tax department of KPMG before running financial planning groups for 2 major insurance companies, as well as advanced planning and education roles with a broker-dealer firm and financial services company. Let's see, what else can I tell you about Michelle? She is a graduate of Emory University, so that makes her very intelligent. Also, she holds her JD from the University of Notre Dame, and then she has a BBA from the University of Notre Dame with a concentration on accounting. So at this time, I'm going to turn it over to Michelle, and she's going to give you some great information. I encourage you to all take notes. This was some good stuff for you. So with that, Michelle, I'll hand it all over to you. Let you take over from here.
Thank you, Rod, and thank you all for joining us today. As Rod's indicated, I want to talk to you about some issues around your financial planning and particularly estate planning. And what we want to talk about today, and can you all see my screen now?
Turn this up louder. I'll try to turn it up louder.
Okay. We want to talk about IRA beneficiary planning, and we'd like to talk about it for a couple of reasons. My team is a team of attorneys and CPAs, and we work with financial advisors in helping supporting the planning that they do with their clients. And primarily, we work on tax and technical issues, and there was a big change in the law in December of last year that could impact some of the planning that you have already done, or maybe incent you to think about doing some planning as we go forward. And it especially revolves around IRA beneficiary planning. For a lot of you, your IRA will be a very significant asset in your estate. And so some things have changed. And we want to make sure as you're doing your planning that the assets that you have that you don't use during your lifetime will go to whom at what time that you'd like to have them pass. And as I said, we've got changes. So now we have to talk about who the potential beneficiaries are and what that means in terms of who they are. Then we'll look at what the distribution rules are for different kinds of beneficiaries and talk about some of the planning that you can do. So one of the things that's important about IRAs is that they pass by naming a beneficiary. So IRAs pass by beneficiary designation. And what that means for us when we're thinking about passing on our estates is that it doesn't have to go through probate. They pass by the beneficiary designation. So that will allow you for your IRA to name who you wish to have receive the assets. And oftentimes the first choice would be a surviving spouse. But as part of a couple, after this first spouse has passed away, then we've got to think further. And do we want those assets to go to children, maybe grandchildren, or maybe it's somebody else, somebody outside of the family entirely? And then the other thing, as you're thinking about your financial scenario, is if you are charitably inclined, an IRA may make a good gift to leave to charity at the time you pass away. The charity is tax exempt, and so if you leave an IRA to charity, it can be deducted from your estate and reduce your estate for estate tax purposes and go to the charity, which is tax exempt, and allow them to have 100-cent dollars to use. We're going to talk through this, but when you otherwise leave IRAs to beneficiaries, they will receive them with an income tax consequence typically. And so if you have a taxable gift, then you may want to use the charity as your beneficiary. So just in general, when we're looking at beneficiaries, what are we thinking about? Well, the beneficiaries determine who gets what when somebody passes away. And so the primary beneficiaries would be the first ones who would be eligible to receive the benefit. But what happens if they're not available? Say you've named your spouse as your beneficiary and your spouse passes away before you do, and you haven't changed your beneficiary designation. Well, then we look to contingent beneficiaries. Now, we want to make sure that we do this planning carefully, because oftentimes, for example, if you were going to name your child or children as beneficiaries, if something happens to one of them, then the money may or may not go to their children. So this is a place where we take a look at the planning we want to do and make sure that we have our designation aligned with who we wish to receive the benefit. Because oftentimes, and this, as you see on the screen where we've named two primary beneficiaries, if one of them has passed away first, then likely the other one would receive all of the money. So if we had a case where we named our son and our daughter as primaries, and if one of them had died first, we would want it to go to their children. We're going to have to be careful with our beneficiary designation and execute it so their share passes on to their children. I mentioned that there were some big changes that happened in December, and they happened through the Secure Act. And the Secure Act made a big impact on IRA beneficiary planning. Prior to the Secure Act, we had basically two kinds of beneficiaries. We had designated beneficiaries, which were people, and non-designated beneficiaries, which were entities. So trusts, estates, and perhaps a charity. And what the Secure Act did was it made changes as to how beneficiaries could receive their distributions. And you see in that first item there, lifetime distribution option eliminated for most groups. They introduced a new class of beneficiaries called eligible designated beneficiaries. So we have still our designated beneficiaries that are people, but certain of the people are special. They're eligible designated beneficiaries, and they are still allowed to stretch out the distributions based on their life expectancy. But for everybody else now on the designated beneficiary side, our other people, that choice is limited to 10 years. And so if you had been looking at doing this planning in the past, your planning may be significantly changed just by the passage of that law. Sometimes people had named their grandchildren as beneficiaries because they figured that their grandchildren would be able to stretch out that money for a long, long period of time. They'd be able to use their life expectancy, and now that's changed. Also, the use of trusts have changed because of the terminology that was put into the trusts in order to assure that some of the money came out every year and went to the beneficiaries. With our new, under the Secure Act, in that 10-year period, there's only one distribution required. So if we had a trust and we still wanted to use it, we have to have that trust reviewed to make sure that it will operate for the beneficiaries that we have currently. These changes also make us think around what other planning we might want to do. And so one of the things that you'll think about as we go forward is does it make more sense to leave an IRA to your beneficiary? Or maybe does it make sense to do some Roth conversions while you're still alive and leave a Roth IRA to your beneficiary? What's the difference? Well, if you leave your IRA to your beneficiaries, if you've taken deductions putting the money into the IRA, when they get the distributions out, they're going to be taxable. If you do a Roth conversion, then what you're doing is you're taking some of your IRA assets and paying tax on them now and moving them into the Roth IRA. And then after 5 years and meeting certain other requirements, that money can come out of the Roth without any tax consequence. So if you are in a lower tax bracket and your beneficiaries are in a higher tax bracket, then you can preserve some of the assets by not having them pay taxes. So this is one of the things you'd want to talk to Rod about, is what's the best way to have your assets positioned in order to optimize the amount of money that's available for your family. Another strategy that people have used prior to the Secure Act is they might have a restricted beneficiary designation on their account. And what it did was it forced the money to be stretched out over time. If that's your case, then this may be impacted by the Secure Act, and that may not be available anymore. So this is a good time to take a look at your IRAs in particular, but all of your accounts in general, to make sure that they are set up in order for you to have assets pass to the people that you want to receive them in a way that is going to preserve the most of the assets that we can. So I mentioned that the Secure Act introduced this new class of eligible designated beneficiaries. So once again, prior to the Secure Act, we had two kinds of beneficiaries. We had designated beneficiaries that were people and non-designated beneficiaries that were estates, charities, and certain trusts. The eligible designated beneficiaries, as I said, can still stretch out based over their life expectancy. So who are we talking about? Well, surviving spouses are eligible designated beneficiaries. And so the way that your spouse can receive the assets didn't change. In addition to that, if you have a minor child, that minor child is an eligible designated beneficiary until they hit the age of majority. Then the 10-year rule will apply for them. But also disabled beneficiaries, and those are essentially people who are unable to engage in gainful activity, and it's defined in the Internal Revenue Code. Chronically ill people who have severe cognitive impairment or are not able to do 2 of 6 activities of daily living, those are eligible designated beneficiaries, and their assets could be stretched out. Also, if you have a beneficiary who's not more than 10 years younger, they qualify as an eligible designated beneficiary. So let's say that we're going to leave your IRA to a sibling who wasn't more than 10 years younger than you, or perhaps you've been in a long-term partnership, but you've never married and the partner is not more than 10 years younger. These people also can still stretch based on their life expectancy. But for everybody else, all the rest of the people, now 10 years. So where we have non-spouse people, 10-year rule. And then for our entities, non-designated beneficiaries, the 5-year rule, if you die before the required beginning date, means that all of the assets have to be distributed by the end of the 5th calendar year. So within 5 years after you pass away. In general, most IRA beneficiaries have to take distributions. Once somebody dies and they leave their IRA to somebody, in most cases, the beneficiaries have to start taking the money out. But depending on who the beneficiary is, will determine how much they need to take and when they have to take it. Because the eligible designated beneficiaries have more options and they have more time. Designated beneficiaries will have the 10-year, and then non-designated beneficiaries, the 5 years generally that we're looking at. So once again, our eligible designated beneficiaries can stretch out based on life expectancy. And they are a spouse, a surviving spouse, a disabled individual, somebody who's chronically ill, somebody who's not more than 10 years younger, and then a minor child until they hit the age of majority. And so typically the way that you would stretch out the distribution over time is to create an inherited IRA. And the way that that works is the inherited IRA is kept in the name of the person who's passed away, and then you add for the benefit of the beneficiary. And that beneficiary can start to take distributions from that IRA. They also have the opportunity to name somebody else who would take the balance of the account if there was still money left in it when they died. However, that new beneficiary is going to have 10 years in order to take that money out. And you don't have to leave the money where it is. If investing somewhere else made sense, it could be moved through a trustee to trustee transfer. So generally speaking, how you get that money out would be through the inherited IRA. So I mentioned that oftentimes, if you have a surviving spouse, they're going to be named as the beneficiary. They have the most flexibility in what they do with those assets. If the surviving spouse is named as the primary beneficiary, there are a number of different things that they can do. They can roll it over to their own IRA, and then they can name their own beneficiary. They could, the other way that they could take over that money in an IRA is they can just change the name on the account to their own name. They also have the option of pulling all the money out in a lump sum. Is the lump sum the best way to take money out of an IRA? I know you're all are shaking your head no, because you know that's how you pay the most taxes. But that's an option, and that's an option for all of our beneficiaries. They can treat it as their own, retitle the account, roll it over. They could take it out over the 10 years if they wished, or they can stretch it based on their life expectancy. If as a spouse you receive the money and you want to take it out based on life expectancy, then there are a couple of ways that that can happen. One is if your IRA is an individual retirement annuity, you could annuitize the account and receive your lifetime payments that way. Otherwise, what you're going to do is take a life expectancy payout, and it works similarly to RMD. If you look at the account balance at the end of the prior year, you go to the table and find what the life expectancy factor is. You divide it by the account value by the life expectancy factor, and you pull out a distribution. A surviving spouse as the beneficiary gets to name their own beneficiaries if for money that's left in the account. And some of the things that we need to think about as a spouse where you are the surviving spouse and you're the beneficiary is what's the best thing to do? So oftentimes we would immediately think, well, I'm just going to roll this over to my own IRA. That would be the simplest thing to do, and I'd have all my assets together. One of the things you need to think about is how old are you? Because if the surviving spouse is younger than 59 and a half, if they roll it to their own IRA, that puts them back in the pre-59 and a half distribution rules. And we'll talk about those on the next slide. If you instead choose to have an inherited IRA, the inherited IRA, the money that comes out is because somebody has died, so there's no 10% penalty. So if you're under age 59 and a half, you can create the inherited IRA and start to pull money out without any penalty. And then once you get to 59 and a half, roll it into your own IRA. And therefore, then thereby you can get money out of the account without having to pay the 10% penalty. And then once again, once you hit required minimum distributions, you would pull money out at that point too. So what if I wasn't aware and I had already gone ahead and I rolled my spouse passed away, I rolled it over to my own, and I was pre-59 and a half. What can I do? Well, if I just pull the money out and just as withdrawals, then I've got the 10% penalty. So I have a choice here. Maybe it makes sense for me to do substantially equal periodic payments, and I can pull some of the money out of the account based on life expectancy for at least 5 years to age 59 and a half, and get the money out that way and avoid the 10% penalty. Once again, once I've taken over the account as a survivor, I get to name who the beneficiaries will be on that money. What if we're looking and we've got an IRA and we feel like our surviving spouse is taken care of with other assets, or we are the surviving spouse and we're looking at who we want to leave these assets to? Well, logically, some of our choices are going to be our children, our grandchildren. There may be, once again, a significant other, or we may be looking at a trust. Now, where we have children and grandchildren and other types of beneficiaries, we have some thinking that we need to do about how to leave the assets, how do we want the money to pass, because we have to look at the beneficiaries and determine, do they have the capacity to manage money? Are they going to make good decisions? What's their income tax situation? A lot of times when we do our estate planning, we've tended to think that every beneficiary should get an equal share of all of the assets. But different kinds of assets have different characteristics. Should we maybe say you had one child who had a high income and a high tax situation, and another child who was in a low income, low tax situation, and you had stocks in an IRA? Do you leave each of them 50% of each, or do you maybe match what you leave to them to their own situation? So when we have these kinds of beneficiaries, here's where we ran into some limits with the Secure Act. So for our non-spouse beneficiaries, their distributions are lump sum. Once again, all of the beneficiaries can take the money out all at once. That will tend to spike their income. That would usually generate the most taxes that you can pay. Otherwise, they have the 10-year payout. And with the 10-year payout, what it means is all of the money has to be distributed by the end of like December 31st of the year containing the 10th anniversary of the person passing away. So you don't have to distribute money every year, but it all has to be distributed by the end of the 10th year. So it is possible to take money out in between the beginning and the 10th year. And it also provides some opportunity to plan. So you sit down with Rod and the beneficiary sit down with Rod and look at, well, what's their income look like? Is it stable every year? Does it fluctuate? Can we match some of these distributions based on what our income tax situation will be? For the non-spouse, and one of the things to really highlight here is these rules came into effect for people who die beginning this year. So if somebody had passed away, if you had inherited an IRA last year, then you could still stretch based on life expectancy. So for eligible designated beneficiaries and where the IRA owner passed last year or earlier, life expectancy payout. And sometimes if the contract is an annuity, then you can accomplish that through a lifetime by annuitizing the contract. Once again, our designated beneficiaries are people. Now, in some cases, the way those people are going to qualify is if they're beneficiaries of a trust, and the trust qualifies under the rules as what we call a C3 trust. So that's a trust that's valid under state law. It has identifiable beneficiaries. It's irrevocable. And a list of the beneficiaries is provided to the custodian. If you don't, and in that case, we look through the trust, we ignore it, and we just focus on the beneficiaries. Otherwise, that trust doesn't qualify and it'll be treated as an entity. So entities include our estates, charities, and the trusts that didn't qualify. Most likely where we, in doing planning, see estates as the beneficiary is where somebody who owned an IRA made a mistake. They either failed to name a beneficiary or the beneficiary they named died before they did. And we don't want the estate to be the beneficiary because you're going to have to pay taxes sooner. Estates are in compressed tax brackets, so you're going to have to pay more in taxes. And the IRA then will be exposed to the creditors of the estate. So the other thing, as I mentioned, this beneficiary designation allows us to avoid probate. If the assets go into the estate, once again, we're subject to probate. In California, Probate can be expensive and time consuming. So to the extent that we can avoid it by getting our beneficiaries in place, that's what we would like to do. And once again, if we go through probate, then we've got to worry about what does the will say, and we've got to worry about the costs. If you don't have a will, then the state law is going to determine who receives the assets. And typically under state law, the assets will be divided between the surviving spouse and the children. So some of the impact of this change is that where we used to be able for a lot of our beneficiaries to stretch over life expectancy, we have a shorter period of time. And that the distributions are taxable, so we're accelerating taxable income. So that can mean that we lose some of our assets to taxes. What are some of the things that we might want to think about to avoid that? Well, I mentioned Roth conversions. Another thing that you might think about is, does it make sense to pull some of the money out of the IRA now and buy life insurance? Couple of reasons you might think about doing that is that life insurance death benefit is not going to be taxable to the beneficiaries. And also you could put that life insurance in a trust. And if you had concerns about the capacity of your beneficiaries to manage money, you could let the trust terms determine how they would receive it. You might, instead of letting your IRA continue to grow and grow and grow, start to pull some of the money out now and spend it down so you have a smaller balance that passed at your death, and then once again consider your charity as charities as beneficiary options. And here's an example of what the tax impact is by this shorter distribution period. So if we take a look at this, we had a person who's 80 years old with a $300,000 IRA that was funded with all pre-tax dollars, named their daughter at 45 as the beneficiary. She has $50,000 in other taxable income. Depending on the way that she received the money, you can see through this chart how much of the money goes away in the form of taxes. So if she took it in a lump sum, then we've paid $66,000 in taxes in the first year, and she has $233,353 left as the asset. If she took $30,000 a year for 10 years, we give up $62,000. If she was able to spread it out over her life expectancy, then we've been able to drop down the tax liability for the money that she receives to $35,570. So distribution over time is our friend for preserving those assets. And here we're just looking at the value of a life expectancy payout. And this is really going to mostly be helpful for people who passed away in 2019 or earlier, because we're looking at, or if you can qualify as an eligible designated beneficiary. So here you see $500,000 growing at 6%. Our disabled child at 50 has a life expectancy for distribution purposes of 34.2 years. Our ability to take that money, invest it, and spread it out over that time means that that person receives $863,651. If we had a disabled grandchild who was 22, now life expectancy stretches out to 60 years, and you see the multiplier effect of smaller distributions over time, and we've grown that asset value to $2,637,151. And the other thing that we just want to keep in the back of our mind about IRAs and how we're going to structure our distribution is that previously, one of the things you think about is leaving it to a beneficiary and letting them stretch an inherited IRA. There was a Supreme Court case where the Supreme Court held that this kind of an asset, an inherited IRA, is not eligible for a federal bankruptcy exemption. And so now we have to consider the capacity of our beneficiaries in a couple of ways. One is, are they good with money and do they have creditors, and figuring out how we're going to position the assets. So what is the best solution for you will depend on your own situation. And one of the reasons that it's important to sit down with Rod and look at the whole picture. If you have a beneficiary where you have some concerns that they might get sued or they might get divorced, maybe the IRA assets are not what you're going to leave to them, or you're going to set it up in trust some way in order to have the trust provide some asset protection. So as we've gone through this, you can see there are a number of different choices and factors that you've got to think about. And you do have some flexibility in how you're going to have these assets passed, but it's important to take a look at the big picture. And it's also going to be really important this year to review your beneficiary designations, IRA in particular, but all of them, to make sure that your estate plan is set up to have those assets pass and to preserve them for your next generation. If you're interested in any more additional information about the changes in the law, we can get that to you. And with that, I'm finished with my presentation, and we can go on to yours or questions.
Over to me.
Okay, you're unmuted.
Okay. All right. Great job, Michelle. Thank you so much. That was some great information. The biggest difference, biggest change rather, that all of you have realized since the Secure Act has passed, which went into effect this year, is previously when your contingent beneficiaries, i.e. your children typically, they would, when they inherited the money, they could stretch it out over their life expectancy. And that was a huge advantage. And particularly, it was a huge advantage to the thrift savings plan, because if you left the monies with the thrift savings plan and passed away, your children would receive it, but they had to pay taxes on everything up front. Well, since the Secure Act has passed, on the inherited IRAs, as Michelle pointed out, they would have to take the money over a 10-year period of time, which still beats having to take it out in a lump sum. We just don't have the luxury of being able to spread that out over their life expectancy. Okay. Well, at this time, we'll go ahead and let Michelle go, and then I'll stick around for any additional questions you guys may have regarding the markets and how the markets are being affected by the election. So I'll address some of those questions. For a lot of you, we've done reviews in the last, most of you, you've had at least 3 reviews this year, at least 2. I would say most of you have had at least 3. But if there's some, I know there may be some nervous jitters because of what's going on in the market. So I'm going to stick around a little longer. But at this time, we're going to go ahead and say goodbye to Michelle. And again, thanks, Michelle, for presenting today.
Thanks for having me. Thanks. It was great. You guys have a great weekend.
You too. All right. So Michelle has left. So any additional questions about the beneficiaries, or any questions about what's going on with the markets? We have the elections just around the corner. We had all the analysts out there on the street had predicted or forecast that we would have volatility leading into the election. I have attended copious analyst virtual sessions and so forth over the last couple months. So we're very confident about the economy. Every time we get, I mean, historically, I can tell you historically, prior to any election rather, markets historically are always choppy. Conversely, historically, after the election, markets have historically bounced really, really strong. And so I had a client recently asking, should we move everything, into, money market or something like that until after the election was over? Our analysts are, definitely not pro doing that. We're not market timers, and trying to time the markets, if anyone could do that, they would have a patent on it. I mean, it is, in my 33 years, I've never seen that done successfully with any level of consistency. And so the key is to have a diversified portfolio, have X amount of the portfolio in bonds, market corrections aren't the worst thing that can happen during those downturns. Our dividends are being reinvested in buying more shares, so we have some compounding that's taken place. And we don't anticipate this to be long-lived. After the elections, if it's really, really close, it could take a couple weeks before all the ballots are totaled and counted. And so during that period of time, typically, even in that scenario, if that would be the scenario, usually there's a pretty good indication who's going to win. So the markets usually are somewhat stable. But if it's really cloudy after the elections have taken place, then that could mean some additional volatility until that has been settled. But our analysts at Raymond James, they have ran scenarios and outcomes with both outcomes. If the blue win or if the red win, you know, Democrats take it, if they sweep, what the economy would look like. If we get a Democratic win and keep a Republican House, by the way, there's only a 10% chance that that will happen. Then they ran out scenarios and what sectors of the economy would do the best, and then scenarios if things remain status quo. So incidentally, all of those outcomes are positives for the markets, okay, quite frankly. And you may not believe this, but the markets really could care less who's in the White House necessarily. At least that's what history tells us, because whether it's a Democrat or Republican, markets have always bounced back after elections, especially coming out of recession. So we all have typically our own personal biases and so forth, but the reality is, hate to burst anyone's bubble, the markets really don't care. What makes markets volatile is the uncertainty leading up to it, okay? And so the key thing that many of you have heard me say over the years, you really want to hold on to this, and that is bull markets are permanent, bear markets are temporary, and smart people steal money from scared people during times of correction, okay? Again, bull markets are permanent, economy continues to move forward, bear markets are temporary, corrections are temporary, and smart people steal money from scared people during times of correction. And over the 33 years, my 33 years, I have found this to be very intentional. So with that, I'm going to open it up for any questions regarding what's going on with the markets and any specific questions relating to that.
And again, feel free to raise your hand or unmute yourself to ask a question.
Okay, all right. Quiet group today. All right, so, well, listen, guys, it was great having all 26 to 30 of you on today. And we look forward to touching bases with you after the elections, okay? Have a wonderful weekend. Be well, be blessed, and we appreciate you, and we look forward to seeing you next month, okay? Bye now.